Good morning. My name is Peter Wilcox, and I'm the president of the Intellectual Property Institute of Canada, or IPIC. With 1,700 members, IPIC is the professional association of patent agents, trademark agents, and lawyers specializing in intellectual property. Our association has been supporting innovation in Canada since 1926. Last week, the Honourable Navdeep Bains, Minister of Innovation, Science and Economic Development, launched the government's innovation agenda. The minister spoke of the need to position Canada as a world leader in turning ideas into solutions, science into technologies, and Canadian startup companies into global successes. However, as acknowledged in the Innovation Department's materials, other countries are moving faster. The minister says that we have to work together to address the gaps that are holding us back from fulfilling our innovation agenda. I'm happy to say that as of tomorrow, one of those gaps will be bridged. On June 24, new provisions of the Patent Act and Trademarks Act will come into force. They will protect confidential communications between clients and their patent and trademark agents made for the purpose of seeking or giving advice with respect to any matter relating to the protection of an invention or trademark, respectively. Such communications with patent and trademark agents, whether or not they are also lawyers, will be protected from disclosure in court and administrative proceedings by a privilege akin to solicitor-client privilege. These enactments bring Canada's laws into line with other jurisdictions that have seen the need for privilege in order to promote full and frank communications between clients and their patent and trademark agents. Privilege in these communications ensures that the best advice is received in connection with establishing these valuable legal rights. The amendment also benefits Canadian innovators looking to grow into global successes, because it will level the playing field if they enter litigation in other countries. For example, in the United States, the courts look to the laws of the country where the communication took place to determine if privilege will apply in legal proceedings in the United States. This is a positive step for Canadian businesses, universities and colleges, not-for-profits, and government agencies that own intellectual property rights. I want to thank the Department of Innovation, Science and Economic Development, Canada, for its work over many years towards this legislative change. I also want to thank Minister Bains for his continued work on innovation, as well as the parliamentarians from all parties who continue to create well-informed legislation that benefits all Canadians. On launching the innovation agenda, the minister called to action every sector of society. Having worked on bridging one gap, IPIC is ready to bridge another by creating a professional regulatory body for patent and trademark agents. We look forward to working with officials, MPs, and senators towards legislation to do so, as well as on other initiatives to continue to support innovation in Canada. Thank you for your time. I'm now happy to take any questions. Yes?
Can you give any examples of specific issues that have arisen because of before these changes came into effect, where there were actual things disclosed or anything like that?
Well, there's examples of cases in Canada in which communications between patent agents and their clients have been forced to be disclosed, including, in particular, an example where a UK patent agent was communicating with their client, and the communications between that patent agent and their client were forced to be disclosed in the context of Canadian litigation, despite the fact that there is UK legislation that provides for a privilege in the UK. So the Canadian court refused to recognize that privilege because there was not a corresponding privilege in Canada. So this legislation corrects those kinds of problems. Yes?
What would this regulatory body look like?
Well, in our view, the profession should be self-regulated, like all other major professions in this country, with very few exceptions. So we would see a college of patent and trademark agents being created with the authority to impose a code of conduct, to impose continuing professional development obligations, to impose mandatory insurance, and to ensure that the correct levels of expertise are involved in patent agent and trademark agent professionals in the country, just as, for example, the Law Society of Upper Canada regulates the profession of lawyers in Ontario.
Any other question? Okay, yes, go ahead.
where does what other changes would need to be made? I know Jim Balsillie has talked a lot about Canada not having the necessary innovation strategy because there's issues with freedom to operate. Do you deal with any of those issues? Because he's saying that Canadian companies can't innovate and catch up the same way and go globally the same way that other countries can because of freedom to operate and because of the limitations surrounding that, because there is no strategy here.
Well, I think that Mr. Balsillie probably makes a couple of points. One is that we haven't necessarily in the past have had a strong innovation agenda, and I think that's something that is being corrected by the current minister and the plans that the Ministry of Innovation, Science and Economic Development has plans for. The other issue that I think Mr. Balsillie has problems with is that there are a lot of low quality patents out there that are preventing people from operating, whether it's in this country or the United States. And I think the issue is particularly acute in the United States, and that's being addressed by laws there to prevent a multitude of patents that might be preventing, in particular, high-tech companies from operating in certain spaces. So that's an issue of really looking at the strength of the substantive patent laws in particular, and I would say in particular in the United States, that is preventing Canadian and other companies from operating on a level playing field, and instead they're being prevented from innovating by some of these patents that are standing in their way. So it's really a patent quality issue that is continuously being addressed by the patent offices and courts around the world. All right. Thank you. If there are no further questions, thank you for your time.